The classic HOA showdown. It's a story a lot of us can relate to, or at least dread. But this isn't just about someone painting their fence the wrong color. This is a real battle over transparency, over procedure, and really over who holds the power in a community. Right from the jump, you can feel the tension. With this one quote, the HOA president basically frames the whole thing as a strategic game. He's saying the homeowner's quest for information wasn't about transparency at all, but about getting a leg up in a legal fight. It really sets the stage for a game of chess, not just a simple disagreement. So let's meet our two contenders. On one side, we have homeowner John Krahn. On the other, the Tonto Forest Estates HOA Board. And what started as a few separate arguments quickly spiraled into a full-blown legal battle, with formal petitions flying back and forth. Okay, so here are the two positions. You've got John Krahn, the homeowner, and his whole argument across all these different complaints boils down to one thing: transparency. He's basically saying, hey, just follow the rules, your own rules and the state's rules. Then you've got the HOA board, who are defending their authority to make decisions they feel are best for the community and their interpretation of those very same rules. And this wasn't just a single issue. Oh no, this thing escalated into a war fought on 6 different fronts. Mr. Krahn filed 6 separate legal petitions, which the court eventually decided to lump together into one giant, complex hearing. So let's break down this battleground. The first fight was all about septic fees. See, the HOA was charging every single property owner for septic system maintenance. But Mr. Krahn raised a pretty logical point. Should undeveloped, empty lots, the ones that literally can't use the septic system, really have to pay for its upkeep? Next up, we have a $75 reimbursement. Seems small, right? But it had huge implications. The board paid back a former board member for a septic part. But the whole case hinged on one little word. Was this a repair, which the HOA could cover, or was it a replacement, which would make it that homeowner's personal responsibility? Dispute number 3 was about a friendly reminder the HOA sent Mr. Krahn to trim a tree. Seems simple enough, but here's the catch. State law says any official violation notice has to tell you exactly which rule you've broken. This reminder didn't do that, which made him question if it was even a valid notice. And then the fight moved into election integrity. The HOA's own bylaws couldn't be clearer. They required a secret written ballot for elections. But after one vote, the board stored the ballots still attached to the signed envelopes. That little detail made it super easy to see how everyone voted, which Mr. Krahn argued totally violated the whole secret ballot thing. Now this is a classic HOA conflict. Mr. Krahn asked for copies of some association records. The law is clear. The HOA has 10 business days to hand them over. But the board refused, saying the records were protected by attorney-client privilege because of all the legal drama. And that brings us to the main event, the big one. Faced with lawsuits for Mr. Krahn, the board decided to tap into its directors and officers' insurance policy. Now, this is a huge financial decision, using community money. But they made the call in a private, closed-door executive session. And the central question became, was that even legal? So yeah, that closed-door insurance decision, it became the absolute heart of this whole legal battle. We're not just talking about an insurance policy anymore. This became a major test of Arizona's open meeting law, which exists specifically to make sure things like this don't happen in secret. Let's dig into how each side saw the law. Krahn's argument was crystal clear. He said, look, the whole point of the open meeting law is to stop decisions from being made in secret. He argued that, sure, the board can go into a private session to discuss legal advice from their lawyer. But the final decision to spend community money, which is what using the insurance policy is, that had to be done out in the open for everyone to see. So it all comes down to how you read the law. Krahn's take was that the law allows for private discussion, but not the final action. The HOA, on the other hand, argued that the decision to use the insurance was a core part of their legal strategy, so it was protected under the exception for pending litigation. And this quote from the HOA president really sums up their defense perfectly. He testified that they were just following their lawyer's advice. They believed that because this was all part of an active legal defense, they, as the elected representatives, had the authority to make that call on behalf of the whole community, without a public vote. All right, so after months of paperwork, multiple hearings, and a ton of testimony, the administrative law judge was finally ready to issue a decision on all 6 of these cases. This is the moment we've all been waiting for, with 6 completely different issues on the table, from a tiny $75 reimbursement to these fundamental questions about how a community should be run. How did the judge rule? Who came out on top? Okay, let's run through the final scorecard. First up, those septic fees on undeveloped lots. The judge sided with the homeowner. That disputed $75 reimbursement? Another win for the homeowner. How about the vague tree trimming notice? Yep, the judge said it was improper. The secret ballot storage? That was ruled a violation too. And failing to provide records? That makes 5 wins in a row for the homeowner. So the final tally was pretty decisive. The judge ruled in favor of the homeowner, John Krahn, on a whopping 5 out of the 6 disputes. I mean, that's a near total victory on all these issues of procedure and following the rules. But here is the twist. The one single case the HOA won was the biggest one. On that core issue of using the insurance policy, the judge sided with the board. The reasoning? Because there was active litigation, the pending litigation exception in the law was strong enough to cover not just the discussion, but the final decision to use the insurance, all behind closed doors. Now, even though he lost that big one, the homeowner's 5 victories came with a price tag for the HOA. The judge ordered the association to pay back Mr. Krahn's $500 filing fee for each of the 5 cases he won. That's a total of $2,500. So you might be thinking, okay, an interesting story about one neighborhood in Arizona. What does this have to do with me? Well, it actually offers some incredibly important lessons for the millions of us who live under HOA rules, whether you're a homeowner or serving on a board yourself. The takeaways here are crystal clear. First, transparency isn't just a nice idea, it's the law. Second, the little procedural details matter a lot. Forgetting to cite a rule in that tree notice was enough to invalidate the whole thing. Third, know your governing documents. The homeowner won 5 times, basically because he knew the rules better than the board did. And finally, for board members, following those rules isn't just annoying bureaucracy, it's your absolute best defense. And that leaves us with one last question to think about. This entire expensive and time-consuming legal mess grew from disagreements over rules that were already written down in a book somewhere. It really makes you stop and wonder how many of us actually know the rules that govern our own communities, and what could happen if we don't.